Good afternoon to all of you from the ISC IMT College of Law. We organize a series of events which include workshop, webinar, uh, guest lecture, uh, sessions, etc. So today we with us as Advocate Mohit Sharma, partner of All India, uh,
It's
all,
all IP care.
all IP Care, New Delhi. Uh, Moiser has experience more than 10 years, and he's dealing the matters in the field of intellectual property right, trademark, copyright, patents, and geography indication. Beside in the three-layer, district court, high court, Supreme Court. So I invite the Advocate Mohit Sharma for deliver the session on the general view of the IPR in a present scenario. Now mic is to yours, sir.
Thank you, Mr. Sudhakaran, for introducing me. As Mr. Sudhakaran has already described myself, let's come to the topic quickly. So our today's topic is the requirement of IPR in present scenario and its practical applicability. As you can see the screen, here you can see one label that is a very well-known brand, Apple iPhone. So in this Apple iPhone, you can easily identify almost every fora of IPR, be it trademark, design, patents, logo, or the copyright. So this is the beauty of IPR, that the IPR, the fora of all fora of IPRs can prevail in a single product itself. So from the logo itself, you can see the logo can be termed as a trademark, as well as their artistic features can be copyrighted. Their name iPhone, be trademark, and their shape can be registered as a design, and their functionalities and the processors can be a part of patent. Now, just to quickly remind, what is IPR? Intellectual property is a creation of human mind. Like tangible properties, their creation has a value, and as with all property, it needs to be protected. Intellectual property rights protect intellectual property as well as help one control and exploit their intellectual property. So as we all know, IPR has different forums, and apart from that, there are 5 main forums of the IPR. These are trademark, copyrights, designs, patents, and geographical indications, that we sometimes call it GIs. Now, what is trademark? The trademark definition is being given under Section 2G of the Trademark Act 1999. In fact, 2ZB. It is a distinctive sign which identifies certain goods or services as those produced or provided by a specific persons or enterprises. It can be a combination of words, letters, or numerals. They may also consist of drawings, symbols, 3-dimensional signs, such as shape and packaging of goods or colors, that is used as a distinguishing features. So as we understand, the trademark is basically a word or letters or a combination of colors. The trademark can be registered by filing the trademark applications and for a period of 10 years. It can further be renewed for further period of 10 years. So these are the examples of trademarks. Here in the screen, you can see some of the labels, some of the well-known labels of some brands. From the left-hand side, extremely left, you can see one product of Camphor, that is Saraswati Camphor. So here you can see the word Saraswati is a trademark, and you can also identify the word R that denotes the registration is itself there, and the whole artistic feature, which is Goddess Saraswati, and the color combinations of this product becomes the part of artistic feature and is eligible to be registered as a copyright. Likewise, other products are given. That is very famous and well-known product, that is Gadi detergent powder. So ghadi here, which is a word mark, is liable to be registered under the Trademark Act. Likewise, their tagline, which is very famous itself, "Pehle इस्तेमाल करें, फिर विश्वास करें." This is also a registered trademark. Similarly, the color combinations of the blue and the white font can be copyrighted. So there is a concept of a well-known trademark. So what is it? So well-known trademark defines that in relation to any goods or services means a mark which has become so as to substantial segment of the public which uses such goods or services, such services that the use of such mark in relation to other goods or services would be likely to be taken as indicating a connection in the course of trade or rendering of services between those of goods or services and a person using the mark in relation to the first mentioned goods or services. All those marks is entitled to be protected under the well-known category. So there is a very famous concept of infringement and one passing off in the trademark law. So before moving to the definitions, we should understand what is infringement. So specifically, Section 29 of the Trademark Act 1999 deals with the infringement, which says that various aspects related to infringement as given in Section 29(1), that a registered trademark is infringed by a person not being a registered proprietor or as a person using by way of a permitted use, uses in the course of a trade a mark which is identical with or similar to that trademark in relation to goods or services. So basically, it says कि जो अगर कोई भी ट्रेडमार्क रजिस्टर्ड होता है और कोई दूसरा अनरजिस्टर्ड और रजिस्टर्ड ट्रेडमार्क जो डिसेप्टिवली सिमिलर हो या मिलता जुलता हो, तो that can be infringed by other mark. Likewise, there is a concept of passing off. So passing off is a common law tort. There is no such provision in Trademark Act for passing off, which can be used to enforce unregistered trademark right. So all in all, if you want to seek the remedy for a registered trademark, you have to enforce your right for infringement. And if you are having a unregistered trademark and still you want to seek for remedy, you have to go for the passing off. So now here we come to the copyright. It is the exclusive right given by a law for a certain term of years to an author or composer, etc., to print, publish, and sell copies of his original work. So the copyright can be given for any literary, dramatic, musical, or for any artistic works, including some cinematographic films or the sound recordings. It is the validity of copyright is first for the period of the lifetime of the author plus 60 years. And after that, it becomes a part of public and is given to the public domain. There is a very important concept in the copyright because copyright registration is not mandatory as per the common law applies. In infringement cases, the rights of the prior user will always prevail. So there is no specific requirement for registration of copyright for seeking any relief for infringement. The third concept is patents. That is a third area of the IPR itself. Patent usually refers to the rights granted to anyone who invents any new, useful, and non-obvious process, machine, articles, manufacturers, or the composition of matters. Their validity is for 20 years, Now, we have to understand that in cases of infringement, what are the remedies we have? In case of trademark or the copyright infringement, if any agreed party wants to seek any remedy from the court, then in that case, what are the remedies available to them? So there are two remedies that is available. One is civil and the other is criminal. Although there are different aspects under which circumstances both the remedies can be availed. Now we have to discuss one by one in what cases the civil remedy is available to us. Civil remedy is filing of a suit in a court of competent jurisdiction. First, civil remedy includes when any agreed party seeks the remedy for infringement of any trademark or copyright, the suit in a competent court of law for seeking the appropriate remedy. They can seek the remedy and relief for interlocutory injunctions, damages, and the accounts of profits. So enforcement, here you can see the enforcement in civil and criminal. दो तरह के enforcement होते हैं हमारे पास, एक civil और एक criminal. Civil remedies में जैसा कि मैंने भी आपको बताया कि हम injunction, stay, damages, accounts and handing over profits और appointment of local commissioners करा सकते हैं. तो civil remedies में हम लोग अभी क्या कर सकते हैं? Civil remedies में हम infringement का सूट फाइल कर हम कोर्ट से injunction ले सकते हैं, जो कि Order 39 Rule 1 and 2 of the CPC Act में हमें स्पेसिफिक एक प्रोविजन दिया गया है जिसके अंदर हम कर सकते हैं. We can also seek for damages, accounts and the rendition of profits. And in these types of cases, जहाँ पे counterfeits and infringements होती है, उन केसेस में हम कोर्ट को एक एप्लीकेशन फाइल करके लोकल कमिश्नर्स को भी अपॉइंट करा सकते हैं, जो which is a part of the court, extension of court itself, जो कोर्ट के बिहाफ पर जाते हैं infringers and the counterfeiters के premise पर for search and inspection of their premises and for seizing the infringing and the counterfeit goods. Now, as we discussed earlier, then we can seek remedy for injunction. So we have to discuss what is injunction. The injunction can be granted ex parte or a bi parte, or any interlocutory order with the injunction can be given, like discovery of documents, preserving of infringing goods, documents, or other evidences which are related to the subject matter of the suit. Or the court can restrain the defendants or the infringer or counterfeiters from disposing of or dealing with the assets for the purpose of damages or for the rendition of accounts or for punitive damages. एक कॉन्सेप्ट और होता है आईपीआर में, that is interpeller order. What is it? Interpeller order is a order which courts give a right to search the premises and seize the evidence without prior warning. क्योंकि ऐसे केसेस में जहाँ पे है मार्केट में, that becomes very imperative to seek these kinds of orders from the court to immediately rush to the premise for its search and to seize the counterfeit goods or the infringing goods. Likewise, एक कॉन्सेप्ट और होता है आईपीआर में, that is John Doe orders. What is it? इसको समझते हैं. John Doe orders, or popularly known as Ashok Kumar orders, usually refers to ex parte interim injunctions issued against defendants some of whom may be unknown or unidentified at the time of obtaining the order. What is it? It is when the identification of a counterfeiter or the infringing or the infringer is unknown. क्या होता है कि काउंटरफेट जब कोई अडॉप्ट करता है तो वो ऐसे गुड्स अपनी आइडेंटिटी को बिना रिवील किए मार्केट में बेचता है। तो जब हम लोग अपनी रेमेडीज को अवेल करते हैं तो उस टाइम हम लोगों को हो सकता है कि हमें ना पता हो कि वो अननोन कौन है या हम उसको ट्रेस ना कर पाए। सो द लॉ गिव्स अस द permission to file the cases in the name of Ashok Kumar, that is John Doe, and to seek the appropriate relief against those persons also whose identity are unknown at the time of filing the suit. A limitation. What is the period of limitation? Suit for infringement. So under the limitation act, it says that a suit for infringement is 3 years from the date of infringement. Although उसके बाद अगर infringement continue हो तो that action gives us fresh cause of action, because new question arises a fresh cause of action. सिविल रेमेडी में जैसा कि मैंने आपको बताया हमारे पास 2 रेमेडी होती हैं, एक सिविल और एक क्रिमिनल। तो सिविल का मैंने आपको बता दिया है। क्रिमिनल रेमेडी में हमारे पास 2 ऑप्शंस होते हैं, टू डायरेक्टली गो पुलिस एंड पुलिस पर जाने से पहले, कंप्लेंट करने से पहले हमें देखना पड़ता है कि हम किस किस प्रोविजंस में हम लोग डायरेक्टली पुलिस को कंप्लेंट फाइल कर सकते हैं। सो इन ट्रेडमार्क the authorities is being given to deputy superintendent of police or its equivalent rank to search and seizure by person, to search and seize. So कौन सा provisions है? Section 115 subsection 4 of Trademark Act 1999, which says the police officers before making any search and seizure shall obtain the opinion of the registrar on facts involved in the offence relating to trademark and shall abide by the opinion so obtained. इसी तरह से कॉपीराइट में अगर कॉपीराइट का कोई केस है तो उसमें हम सेक्शन 63 के अंदर हम लोग कंप्लेंट फाइल कर सकते हैं पुलिस को और डायरेक्ट टू रजिस्टर द एफआईआर। यही रेमेडी अगर हमने कोर्ट से अवेल करनी है तो एक कंप्लेंट फाइल होती है अंडर सेक्शन 156 सबसेक्शन 3 रीड विद सेक्शन 200 ऑफ सीआरपीसी 91 एंड 93। अगर कोर्ट को प्रमा फेसिया लगता है कि देयर इज एन इन्फ्रिंजमेंट, इन दैट केसेस द कोर्ट कैन डायरेक्ट ऑफिस register the FIR. Now we have to directly come to the our core topic, that is a requirement of IPR in the present scenario. आज के समय में IPR की रिक्वायरमेंट क्यों है? जैसा कि आप लोग सब समझते हैं कि आज के टाइम में अगर किसी को भी अपने प्रोडक्ट को पॉपुलर करना हो या इस ग्लोबलाइजेशन में अपनी सेल को इंक्रीज करना हो या फिर अपने प्रोडक्ट को मार्केट में लॉन्च करना हो, तो एवरीवन नीड्स a specific trademark, the color combinations, a specific representation, and for that purpose, it is imperative to adopt a specific trademark, the color combinations for identification of any product. So आज के समय में in the area of digital era, आप लोग देख सकते हैं कि in the time of Amazon, Flipkart और other e-commerce platforms, जहां पर infringing और counterfeit goods आज भी अवेलेबल है, तो उनको अपने राइट्स को प्रोटेक्ट करने के लिए IPR की कहां रिक्वायरमेंट होती है, ये हमें देखना होगा। जैसे कि आप देखा होगा कि आप एक साइबर स्क्वैटिंग का कॉन्सेप्ट होता है, जहां पे one person holds a domain name for the purpose of selling it out of greed or for profit. So here's the requirement of IPR comes in to protect from such cyber squatting. इसी की तरह ई-कॉमर्स पर Amazon, Flipkart, IndiaMarts, जहां पर आज के समय में बहुत सारे इन्फ्रिंजिंग और काउंटरफिट गुड्स अवेलेबल होते हैं, तो ऐसे समय में बहुत जरूरी हो जाता है कि IPR में जो एरियाज हमें दिए गए हैं और जो उसमें लॉज और प्रोविजंस एप्लीकेबल होते हैं, उसका हम सही तरह से इम्प्लीमेंट कर पाए। और उसके लिए ये बहुत जरूरी है कि क्या क्या स्टैट्यूटरी प्रोविजंस और क्या क्या रेमेडीज एक रजिस्टर्ड यूजर और एक अनरजिस्टर्ड यूजर को भी मिलती है। तो जैसा कि आपने देखा होगा कि आज के समय में जो फ्लिपकार्ट और जो अदर ई-कॉमर्स वेबसाइट्स पे जो सामान मिलता है, तो उसको किस तरह से हम ट्रैक कर सकते हैं। उसके बहुत सारे तरीके होते हैं ट्रैक करने के। उसमें से एक तरीका ये भी होता है कि हम ट्रेडमार्क के नाम से ही उसको पहचान सकते हैं। कई बार क्या होता है कि जैसे से फॉर एग्जांपल एक अभी जैसे कि मैंने आपको स्लाइड शो में दिखाया था, सरस्वती कैम्फर के नाम से ही एक प्रोडक्ट और भी मार्केट में ऐसा आ सकता है जो अलग नाम से हो, लेकिन उसका आर्टिस्टिक फीचर्स, कलर कॉम्बिनेशंस, गॉडेस सरस्वती सेम हो। तो जो कंज्यूमर्स हैं, they can be deceived, they can be duped from this fact only that these product comes from the same source of origin. So इस ऐसे केसेस में बहुत इंपॉर्टेंट हो जाता है कि हमें ये देखना कि कौन सा असली है और कौन सा नकली, तो इसकी आइडेंटिफिकेशन बहुत जरूरी होती है। इसी तरह से लोकल मार्केट्स में भी आजकल काउंटरफिट्स और इन्फ्रिंजिंग मटेरियल्स बहुत आसानी से मिल जाते हैं। तो जनरल पब्लिक का एक व्यू ये होना चाहिए कि उसको किस तरह से आइडेंटिफाई करें, उसके ट्रेडमार्क को, कॉपीराइट को, और किस तरह से हम उसको डिफरेंशिएट कर पाए। इसीलिए आज के टाइम में रिक्वायरमेंट, IPR की रिक्वायरमेंट बढ़ जाती है, जो एक रजिस्टर्ड यूजर और एक अनरजिस्टर्ड यूजर को भी एक राइट देता है टू सीक फॉर एनी appropriate remedy from the court or from the police officials. इसी के साथ साथ रिक्वायरमेंट IPR की वहां भी बढ़ जाती है। जहां पर हमें अपने राइट्स को इन्फोर्स कराना हो, क्योंकि IPR में 3 कॉन्सेप्ट्स आते हैं, प्रोसिक्यूशन, लिटिगेशन एंड इन्फोर्समेंट। तो लिटिगेशन का तो मैंने आप लोगों को अभी बता ही दिया है, सिविल और क्रिमिनल एक्शंस हम लोगों के पास एप्लीकेबल होते हैं, हमारे पास अवेलेबल हैं। इसी तरह से प्रोसिक्यूशन में हम ट्रेडमार्क, कॉपीराइट्स, डिजाइन्स, पेटेंट्स और ज्योग्राफिकल इंडिकेशंस की एप्लीकेशंस बिफोर देयर रिस्पेक्टिव बोर्ड्स और रजिस्ट्रीज हम लोग फाइल करते हैं फॉर देयर डेफिनिट टाइम पीरियड्स फॉर द रजिस्ट्रेशंस। इसी तरह से एक पार्ट आता है इन्फोर्समेंट का, जो हम कोर्ट से या पुलिस ऑफिशियल से हम एक प्रॉपर ऑर्डर्स या डायरेक्शंस लेकर अपने राइट्स को इन्फोर्स कराते हैं। So these all foras of IPR, that is prosecution, litigation and the enforcement, is very important and required in this present scenario. I think we have already covered so much about the IPR and the requirement of IPR in this present scenario. Rest I'm leaving to Mr. Sudhakaran.
Thank you, sir, for explaining the importance of IPR in the present scenario.
Thank you so much, sir.
Hello. Hello, Mohit sir.
Yes, sir.
Your presentation has been over, sir.
Yeah, I think I have covered almost everything.
Okay. So, I just.
Is there any queries or questions from the audiences?
Just I am asking, sir. Dear participant, if you have any query from the speaker about the current scenario of IPR and how the IPR will be applicable in the modern scenario, then in that circumstances you can ask. Yes, Neha, what is your query? You can ask from the speaker.
Good evening, sir.
Good evening.
Good evening, Mohit, sir.
Good evening.
Yes, sir. My question is that whenever we file for a trademark or a patent, so it is quite possible that we can get any objection from the other side, because they also review the a patent application which we are filing. Like in US, we get office action or final office action, and we reply for it. So I wanted to know that in India, if we file for a patent or for a trademark, so what are the objections which we can get, and what are the replies which we can file from our end?
See, whenever any public or a person has any grievance or they can file their objections before the respective registry. In that case, the registry issues an examination report for the particular patents or the trademark or the design, as the case may be. And then in that case, we have to file a detailed reply to that objection. If the registry is satisfied, in that case, that patent be published before the general, and thereafter, if anyone has any grievance, they can again file their opposition and so on. This way, the
Yeah,
application.
sir. So do we have to Yes, sir. Sir, so do we have to mention the distinctiveness like in the case of patent? So do we have, whenever we are filing a reply to any objection, so do we have to mention about the distinctiveness of our product and whether it is a real invention or not?
Yes, yes. That's why I said earlier, we have to file a detailed reply about the descriptiveness and everything that you want to rely upon your application. And if the registry satisfies that it is a case of uh, any new invention or any uh, novelties, in that case, the patent or the design can be published.
Yes, sir. Sir, and what is the time?
Sorry, I could not hear you.
Hello. Neha, what is your question and doubt? I think maybe some technical issue has been there.
Yeah, yeah.
Moisture, can you tell me what is the difference between the uh, passing off and the infringement of trademark? It is registration. It is whether they are the same or they are the some differ.
Sir, infringement can lie in the cases of registered trademarks, and the passing off can lie only in cases of unregistered trademarks. One can seek remedy for infringement in cases of registered trademark only, and passing off can be of goods. Infringement can be of marks, and the passing off can be of goods only. So that is the difference.
Okay. Suppose if the registrar has after turned down the application, so what remedy can be there? Whether we can file in before the court or we have to again move to the registrar for the rejection of the application.
In that case, we can file the review petition before the registry itself, or we can file the appropriate application before the court also.
Okay.
Sir, can I ask one more question?
Yes, sir. Continue.
Yes, sir.
Continue.
Sir, yeah. So I wanted to ask that what is the limitation period in India when we can file a reply to any objection?
See, as per the registry, the time given is that depends upon the application to application, and sometimes it gives 30 days time to file the reply, a particular reply. I mean, it's not been given in that time the application stands as abandoned.
Okay, sir. Sir, and if there is a particular objection,
Yes.
sir, if there is a particular objection for any trademark or a patent, so the overall time period will be, I think, from 3 to 4 years for that.
No, no. There is no provisions for disposing of any application.
Okay, so there is no provision about
There
that.
is no time-bound manner in which the application is to be rejected or is to be decided.
So if we take a rough idea, it will take around 3 to 4 years for a trademark if it is stuck.
No, no, it cannot be said like this.
Okay, thank you.
Yeah, you're welcome.
Participant, if you have any other query regarding the practical aspect of a IPR, you can ask to our learned guest. He is a well sound in the practical exposure of a point. Or moisture, what are the remedies to the client if suppose if a compromise has been there in a civil matter, whether it will be effect to the criminal matter for the infringement of trademark, if the
No.
matter has been in both ways?
It depends. If the infringing party continues with the same cause of action, then it will gives us the recurring cause of action, continuous and the recurring cause of action. If he adopts a new label or the mark or the infringing mark, then it will definitely gives a fresh cause of action. In that case, it will not affect the subsequent litigation.
or, or hello.
Hello. Yes,
Uh,
Mr. Sudhakaran.
my voice is audible.
Yes, yes, you are audible.
Apart from this, sir, what is the time limitation for carrying out the raid in terms of a criminal? Suppose if a accused person is trying to sell the district and the similarity product, which is create a confusion in the minds of a public. So, any time frame is there in the field of a criminal law for
No,
carrying
as
out
such,
this raid operation?
no, as such, there is no time period has been given. But as early as you satisfy the court with the evidences that something counterfeit goods are selling in the markets, then court, upon satisfying themselves, can issue the proper directions to the court to the police officials for conducting the raid. But as such, there is no time period is given.
Okay. Okay. So, participant, any more question here? You can ask from our guest. I think all the queries has been sorted out by our learned guest. So, on the behalf of ISC IMT College of Law, I propose the vote of thanks for the patience listeners and the wonderful presentation given by our learned guest, Advocate Mohit Sharmaji, in a
Thank you very much.
wonderful
Thank you very much.
PowerPoint presentation where he has thoroughly explained the concept of a IPR in a general scenario. He has covered the trademarks, copyright aspect has been there. One more question I will ask to the
Yes, please.
uh, what is a time frame for the filing of a copyright and the expiry period of a copyright factor?
Are you asking for the copyright?
Copyright.
See, copyright can be, the validity of copyright is for the lifetime of author and plus 60 years.
Okay.
And since the registration is not required, is not necessary for seeking any relief of infringement of copyright, so you can file the applications at any time.
Okay. So whether the copyright can be sell off?
Yeah, it can be transferred. It can be assigned as well.
Also, it can be transferred, it can be assigned. Okay. So now I will just wind up this session. Thank you very much to all of you.
Thanks to all.
Thank you, sir. Thank you,
Special
Mohit.
thanks to Dr. Sudhakaran.
Yeah, this was an insightful session. Thank you.
Thank you.
Thanks to all.
Same here. Thank you.